A couple of decisions today out of the Supreme Court. We covered many of them today, but we want to hit some more, most specifically on some cases that the court has decided to take up in the future, and in one case, an issue they've chosen not to take up, both making headlines. And joining us right now, Ken Klukowski, who's the general counsel of the American Civil Rights Union and legal editor at Breitbart News Network. Always good to have you, Ken.
Oh, it's great to be with you, Larry. Thank you.
That time of year when we get lots of decisions. We had the folks from the Alliance Defending Freedom on in the last hour to talk about the religious liberty cases today. I want to talk to you first about what the Supreme Court decided with regard to the travel restriction executive order from the Trump administration. Mixed signals on this one based on reaction I'm seeing. What do you say?
This was a fascinating decision, and I think looking at it now, not unexpected. Where the court majority, so we're talking about the moderate and liberal members of the court, and I think I would put the Chief Justice more in that moderate category, is by a 6-3 vote. The court granted a partial stay. Now, in that, they said that the parties in this case, the plaintiffs in the lower courts, and similarly situated individuals and groups, they're leaving the injunction in place with respect to them, which is what keeps this matter live, but saying that they're staying it in all other respects, and then they go through some pretty narrow reasoning as to why that's the case. Justices Thomas, Alito, and Neil Gorsuch concurred in part, but dissented in part, saying that they would grant a stay in full. They would do a full stop of everything the lower courts had done to block these executive orders. All of them unanimously agreed that they should hear this case in the first 2-week sitting of the court's next term, which will be the first 2 weeks of October. So there, I think by that point, I think we're going to have extensive arguments about whether the plaintiffs even have standing in the case. If they do have standing today, there will be a question if, for example, these vetting processes can be put in place by the first week of October. Then there'll be a very serious question as to whether the case has become moot. That even though the plaintiffs have standing to sue right now, they would no longer be injured and thus no longer be able to pursue litigation by the time we get to October. Only if both of those are satisfied, and I think those are both very big question marks, then we get into the question once again of whether the president's actions are consistent both with federal statute and the U.S. Constitution. My answer is absolutely yes when it comes to both questions, but again, we'll see what the Supreme Court would say.
Well, so I'm of two minds. I interviewed Andrew McCarthy earlier in the day on this one, and he thinks it's a mixed bag as well, in that he believes that there are some very important overriding constitutional principles that should be determined here, and it would be good for the Supreme Court to weigh in and sort of smack down the lower courts on this.
It would be nice for the Supreme Court to do it, but part of one of the essential protections for liberty in the Constitution when it comes to judicial power is that the courts can only exercise their own power consistent with the Constitution, and one of the requirements of Article 3 of the Constitution is that a court must have a justiciable case before it in order to have authority to issue any decision, and that includes both that the plaintiffs must have standing and that the case must no longer be moot. It needs to be a live controversy with presently injured parties who are making the case as to why the court should rule in their favor.
All right, and that will come into play when, in fact, they take this up and how far along the administration has gone in implementing the extreme vetting and such over the next several months.
Yeah, that's correct. I would add one global observation. I'll have a piece on Breitbart tomorrow on this. We have now seen Justice Gorsuch weigh in a half dozen different areas over the past couple weeks. I have to say, this guy has come out swinging. He is solidly aligned in the originalist, constitutional, conservative wing of the party. It appears he's often grouped now, I think, with Justice Clarence Thomas. To a couple times he even moved to the right of Justice Alito. President Trump promised someone who would be a worthy successor to the late Justice Antonin Scalia, and it looks like he hit the ball over the fence with Neil Gorsuch in that regard. He has come out as a very serious, very strong conservative justice.
And to that end, he joined Justice Thomas in a dissent with regard to a case case that the Supremes chose not to take up. This has to do with the Second Amendment, has to do with the state of California, where a San Diego man said that the policies where he had to prove, and this should resonate with anyone here who lives in Washington, D.C. or in Maryland, where you have to prove that you have good cause to conceal carry when you leave your home. This is a question as to whether Second Amendment rights extend beyond your domicile. Why did they choose not to hear this case, Ken Klukowski?
Exactly right. It was a perfectly designed case, perfectly argued by former U.S. Solicitor General Paul Clement with the support of the National Rifle Association. And that's right. It was constructed in such a way where the issue was, okay, both Supreme Court gun rights cases involve people with guns in their home. Does that right extend beyond the door of your home? Of course, the answer for any conservative is yes.
Of course.
But this was a perfect case to explore that. I think between this and the other gun rights case that they declined to take up, one where the conservatives won, and it was two liberal justices who dissented from the court not taking that one up, I think looking at both cases together today with four justices wanting to take different cases but not the others, I think it may mean that right now with the current composition of the court that there is not a clear majority one way or the other to continue developing constitutional law when it comes to the Second Amendment. All that could change if President Trump gets another vacancy on the U.S. Supreme Court.
Which leads us to my last question. Only 30 seconds left, but I'm seeing these headlines, Ken Klukowski, about Justice Kennedy not telling his clerks one way or the other whether they'll be back. What are you hearing?
It's, in this kind of a thing, you can't trust any of the rumors, Larry, because sure, it's possible that Justice Kennedy did whisper something to someone, but we have no way of knowing if that's the only person in town we should be listening to. It looks like guesswork to me. A traditional time to announce your retirement is from the bench on the last day. That was this morning. It did not happen. The justice could announce his retirement in July or August, or he may choose to live. I'm sorry, not just to live, Mike.
To serve, you mean? Yes.
That's right. Forgive me, Justice Kennedy.
Understood. We certainly hope the good justice is going to be living.
Continue serving for another year.
Thank you, Ken Klukowski, General Counsel of American Civil Rights Union, legal editor of Breitbart News Network. Always good to have you, sir.